A new legal regime is set to be ushered in the Nigerian legal profession as a bill is in place to repeal the Legal Practitioners Act of 1975. The question is, why now? This is how we welcome you to the courthouse this week. Our Law Class 101, we're taking a look at the legal profession and why the need to repeal the Legal Practitioners Act. When we return from this break, we'll be telling you who our learned legal practitioner for the week is.
From Lagos
to London, from Johannesburg
For several years, our economy
to the United States,
identifying houses of worship.
we have all the world covered for you, no matter where you are.
Love with News is at the heart of it all.
Have experience.
We bring you our perspectives of stories behind the story.
The signs given to us for the entry of these things are before us.
Join us.
Join us.
Join us on this station.
You're welcome back with the conclusion of the 60th Annual General Conference of the Nigerian Bar Association. A lot of issues has been coming to public knowledge, and people are wondering how united is the NBA, and now we're seeing a bill proposing a repeal to the old Legal Practitioners Act, and the question remains, why now? We seem to be asking a lot of questions, but as usual, we're joined by a legal practitioner, a seasoned legal practitioner, who will be giving us his views on why he feels this bill is coming to the fore at this time, and of course, we'll give you some sections of the Legal Practitioners Act that is going to be changed or amended, and is none other than Vincent Okoroafor. Vincent, you're welcome to the courthouse.
Thank you very much. Thank you, viewers.
And you know, I said the 60th Annual General Conference of the NBA ended a while back.
Yes.
And of course, it was the first virtual conference where
yes.
lauding the innovation
Yes.
with the election of Olomu-Agbodo into
Yes.
as the president of the Nigerian Bar Association. Then we
Definitely.
started seeing some funny developments. We saw the new Nigerian Bar Association, we've seen Bosan, we've seen different things. But first of all, before we go into all the drama in the NBA at the moment,
Yes.
why do you think that there's a need to repeal, or there's a bill seeking to repeal the Legal Practitioners Act at this time?
Well, thank you very much. The Nigerian Bar Association has come of age. The first Nigerian lawyer to be enrolled at the bar, to practice at the bar, was actually called in 1889. That was quite some years back. I think the late Christopher Sapara Williams.
Sapara Williams as a Queen's Counsel.
Yes. And it took quite a while for a body of lawyers to come together to form an association called the Nigerian Bar Association. As far back as 1933 or thereabout, the idea was, the idea came up to have an association of this nature. And then when the Nigerian Bar Association was finally formed, it became necessary that it should be backed, there should be an enabling law in that regard. And in 1975, we had the Nigerian Bar, the Legal Practitioners Act, which to an extent regulates the activities of the Nigerian Bar Association. And then over time, there had been this calls for reforms. And I see it as a very good development for us to have a reform in the legal profession in Nigeria as a whole. However, we find that the draft bill has generated That's a draft bill to repeal
the Legal Practitioners'
the Legal
Act.
Practitioners' Act, and to enact or reenact the act, so to speak. We find a lot of controversies here and there surrounding some of the sections, particularly the first section itself. We have about 18 sections or thereabout in the draft bill, and then that bill is presently, undergoing the passage of the second reading or thereabout. And then we have from the first section itself.
The very first section itself.
That is where
the controversy started.
We've been having
from the very beginning.
A lot of storm in the teacup. And so we have, for instance, section 1 now makes the body of benchers a body corporate with perpetual succession and a common seal. That means the body of benchers can be sued or can sue in its, as a legal entity at present. And so we have the body of benchers now as a body corporate, and then section 1, subsection 2 of the draft bill also gave a kind of should I call it? Gave some kind of roles or powers to the body of benchers, so much so that they could undertake to make regulations to, at least
the affairs.
Yes, and then when they make such regulations, it is to preserve the traditional value of the legal profession itself. And then we find another subsection of that section 1 of the draft bill, talking about the constitution of the members, those who are to be members of that body of benchers. We find that, unlike in the extant act, we find that the neck of the NBA, that's the National Executive Committee, in the extant act could actually nominate 30 members. But in this draft bill, it has been reduced to, the nomination has been, the nomination has been reduced to 20 or thereabout. And then we have an additional 5 posts, or how will I put it now?
Positions.
Or positions meant for certain kind of members, who have attained some criterion, or is it criteria now? For instance, the president of the National Industrial Court.
We'll be taking some of these sections one after the other.
Yes.
So let's see. The bill, first of all, the long title of the bill is described as a bill for an act to repeal the Legal Practitioners' Act, Cap L11, Laws of the Federation of Nigeria 2004, and it's to reenact the Legal Practitioners' Act to provide for reforms and regulate the legal profession and for such other matters therewith. Now, you've given us a background to the old Legal Practitioners' Act, and the question is, are there any defects? Do we have any defects in the old act that really requires this repeal? Why the repeal? Any defects in the 1975 Act that has been governing the legal profession to now necessitate this amendment or repeal as the bill is proposing?
Well, to first ascertain if there is a defect, we must first look at the vision and mission of the NBA.
Okay.
We must look at its motto, upholding the rule of law, or we also generally look at its vision. I think the NBA, by its constitution, had always made it abundantly clear that it's from the onset, it actually set out to uphold or to ensure and promote the rule of law, in Nigeria. And then it has also sought to be the voice of the voiceless. In other words, to challenge any form or any act that may tend to suppress and oppress the masses. And so we have the NBA also sharing views and similar ideas with similar associations. It also has an observer status with the African Commission, or the African as regards the African Charter on the Human and People's Rights. It has an observer status. And then it has a kind of synergy with some national, other national bodies or associations, or international bodies and associations. And so the MBA, if we tend to look at its mission over the years, we find that it took the MBA about 103 years, after perhaps the first lawyer in Nigeria was enrolled to practice as a lawyer. Took, should I say, lawyers generally, to find their voice as per defending the rule of law in Nigeria.
Even that is still questionable, because a lot of people have been saying the MBA has been quiet in a lot of issues. So I've already found your voice. The MBA, have you found your voice?
The MBA found its voice on the 3rd of July, 1984, 85. That should be during the military regime of General IBB. Then we had a former governor of Gongola State who disregarded and flouted court orders. And then he also made some uncomplimentary remarks against the judiciary. And then the MBA rose up and said, no, we've had enough. As at then, the MBA called for a boycott, 7 days boycott. Unfortunately, before the 7 days boycott could be effectively actualized, the military governor of the then Gongola State ran to court, got an order to stop it midway.
Okay.
And then also under the regime of, under the Olomu-Agbodo and the Buhari regime in the military era, 1984, when the 2 decrees, 2 most notorious decrees that we ought not to remember, Decree 2 of 1984, which has to do with detention of persons, state security and detention of persons, which means the government at then could just pick anybody and then
detain a person and say it's for national security.
Exactly. Then Decree 4 of 1984, Public Officers Protection Decree, which sought to protect them from what they called false information, which is giving us a deja vu with the so-called hate speech, whatever bill. So you find the MBA rising up to the occasion then. But although it was sort of like we had more of individual lawyers, like the late Chief Gani Fawemi.
Yes.
And we have the indefatigable Femi Falana SAN. And we had some social rights crusaders, like the late Dr. Belkor Sokuti, of blessed memory. We had, some other social rights crusaders who were not even lawyers, but they were so passionate about fighting for the rule of law. And you find that when you look at this, the mission of the MBA over time, up till 1984, down to the General IBB's Babangida's regime. And then you found that under the able leadership of a female national leader of the Nigerian Bar Association, Chief Mrs. Priscilla Kuye, as at then under the IBB's regime, she rose up. She was a real legal Amazon.
Why is MBA against some of these sections, like we see the inclusion of the body of benchers, giving them perpetual succession and all that. And now, this same period, we had the passage of the amended Companies and Allied Matters Act, which would also affect the NBA as a non-governmental organization, really. So why these legislations at this time?
If you look at the new Companies and Allied Matters Act that was recently passed into law, or which repealed the one of 1990 and was reenacted, you find Section 839, which had been a very controversial section, which some persons have shown, viewed their concerns, saying it is a kind of, will I call it a way or method by which they fear that the government, that the federal government, might come into the activities, the private activities of, non-for-profit, organizations. And that section, I'm very sure, will be seriously resisted by the Nigerian Bar Association if it comes as a threat to its private activities. And so it appears that the National Assembly has also looked at that session, looked at the Nigerian Bar Association and said, okay, so what do we do? If rather than going through section 839, let's go through
the Legal Practitioner's Act.
Same bill, because the key that opens is the same key that locks. So why not we take up the same key, which is the act itself, repeal it, amend it, and put similar provisions to that of section 839 of KAMA
into the Legal Practitioner's Act.
Yes, the draft B now has something, though not
very obvious.
Not obvious, but then when you look
there,
when you look deeply, you will find that there is the voice of section 839 of KAMA, and then the hand of section 1, or is it section 3 now, of the draft bill, which seeks to reform and
repeal the Legal Practitioner's Act.
So,
because I'm very, very interested in this repeal and those sections, we'll come back and take some very deep look into some of these sections, particularly as it's going to affect the activities or the independence of the legal profession through the Nigerian Bar Association. But you've been listening to Vincent Okoroafor, a legal practitioner, constitutional lawyer, and of course he is a lawyer of many years. We'll be taking a listen to our reports on this proposed reform and some of the sections as well, and our legal nuggets. We will be right back. To say the 1975 Legal Practitioners Act is long overdue for change is nothing short of an understatement. One would have thought that the proposed Legal Practitioners Act would be introducing more innovation into the legal profession and not adding bottlenecks, which would subject lawyers to what some believe is unnecessary scrutiny. Initially contained in Section 3 of the 1975 Act, Section 1 of the proposed bill now provides for the establishment of body of benchers. In addition, the body of benchers have the following powers: to determine the duration of a caretaker committee, not exceeding 12 months. The disciplinary powers of the body shall be regulated by rules to be made by the Chief Justice of Nigeria. Section 3 of the bill is a new innovation. Subsection 1 provides, there shall be established for the body the office of a secretary, who shall have a career service and shall be appointed by the body of benchers. Meanwhile, the secretary has been charged with several duties which include execution of policies, administration of secretariat functions, in charge of call to bar and law dinner, amongst other functions. Section 5 of the bill provides for the composition and proceedings of the Bar Council. Significantly, Section 1 of the Act has a similar provision. Meanwhile, the Act says the members are Attorney General of the Federation, Attorneys General of the States, 20 members of the NBA. Section 7 provides for the practice as a legal practitioner. It is to be noted that Section 2, Subsection 1 of the Act provides, subject to the provisions of this Act, a person shall be entitled to practice as a barrister and solicitor if and only if his name is on the roll. However, there's an additional qualification in Section 7 of the bill, saying, a person is entitled to practice as a legal practitioner only if his name is on the roll of the legal practitioners kept at the Supreme Court of Nigeria and he has met all the conditions for practice set out in this Act and any rules made by the body of benchers. General Counsel of the Bar. However, the inclusion of the General Counsel of the Bar as part of its committees may appear to have been laced with ambiguity. This is because the Bar Council is an independent body already established in Section 5 of the bill. While some lawyers believe that there's innovation in the proposed new bill, some others believe that there's just a rearrangement of sections and an interference with the activities of the legal profession. Most lawyers are also against provisions introducing members of the House of Representatives and other non-lawyers into the affairs of the NBA. Lawyers are actually not pleased at the level of interruptions that they will have to deal with if this bill gets passed into law. Yeah, welcome back. This is still the Courthouse. We're talking about the legal profession and the proposed repeal to the Legal Practitioners Act of 1975. And Vincent Okoroafor has been answering questions as to why he believes they're trying to repeal or amend or totally annihilate the provisions of the 1975 Act. And this time around, we're going to start with the issue of the President of the National Industrial Court, live benches, the President of the Senate, the Speaker of the House of Representatives, and the Chairman of the National Assembly Committees on the Judiciary. What is that about?
Well, it's quite, that is something strange in the whole reform, because I do not think that is actually needed at this point in time, because it is a kind of contradiction, or would I say it is making the draft bill self-contradictory. In other words, if you look at section 3, or is it, when you look at section 1, subsection 3 of that draft bill, or section 1 generally, it talks about that the members of the body of benches shall consist of lawyers of the highest distinction in the legal profession. Now, when you talk about, the emphasis there is the legal profession. Lawyers of the highest distinction in the legal profession itself. So the emphasis should be on the legal profession. Now, what role does the President of Senate and the Speaker of the House of Rep, or even the Chairman of the Committee on the National Assembly Committee on the Judiciary, I wonder what criterion or criteria was used to factor them into
So are they going to, going forward, are they also going to amend the Constitution in such a way that to provide for only lawyers to occupy those positions?
Now, they are saying, yes, in that same draft bill, they are saying it can only be practicable where the President of Senate, the Speaker of the House of Rep, and the Chairman of the Judicial Committee, yes, are legal practitioners.
But of the highest distinction.
That is it. Are they lawyers of the highest distinction in the legal profession? Not in politics. Then let the third estate of the realm remain where it is. There should be no interference by the principle of separation of powers. I've always said, let's make sure that the judiciary remains the judiciary.
The executive remains the executive.
And the
legislature remains
the legislature. Yeah. So the judiciary, with every other appurtenances surrounding it, should remain where it is. Now, the MBA has always been on ground to ensure that the judiciary remains impartial, remains, how will I put it, independent. Yes, that's the proper word. Remains independent without any interference from the executive or from the legislatures. Okay. So if the same MBA is now to be regulated by politicians who cuts across other arms of government, then it will begin to see some kind of friction later in the future. What I'm now saying is, I'm not saying the President of Senate, if he's a lawyer, cannot be among the body of benchers, but then he should not be there in the capacity as the President of Senate. Yes. Being the President of Senate, to me, does not make for a distinction or for the highest distinction in the legal profession. It may be the highest distinction for a politician in Nigeria, but not for the legal profession. And then being a Speaker of the House of Assembly does not make that lawyer occupying that position of the highest distinction in the legal profession. So that particular section of that draft bill, trying to foist the Senate President and the Speaker and the Chairman of the Committee on the Judiciary into, or try to factor them into the affairs of the NBA, is actually contradicting another section, an earlier section which says they must be lawyers of the highest distinction in the legal profession if they are to be members of the body of benchers.
When we heard about the proposed repeal and amendments of the Legal Practitioners Act of 1975, the first expectation was that there will be maybe provision, apart from the practice directions sent by the Chief Justice and all that. We felt there will be a provision for virtual court hearings, a provision for fast-tracking the justice dispensation and things that a lot of people have been complaining about. We didn't know it was going to be more on regulating and supervising the activities
kind of
the
politicizing
legal profession.
Legal profession, so to say, because that's the fears of many as it is now.
So last word on this.
Yes, so the last word on this should be, it is a good thing to reform and to regulate the legal practice or the legal profession in Nigeria. But let's do it transparently under, a transparent democratic setting, and having in mind that the progress of the nation, the unity of the bar, and the progress of the bar and that of the nation should supersede any other interest.
Definitely, definitely. And I was going to ask you about the BOSAN, Body of Senior Advocates of Nigeria, trying to investigate the just concluded election of the president of the NBA and some other activities of the NBA. Generally, different things going on, but I think we'll do that some other time.
Yes.
But you've been on the courthouse before, quite a long time ago, but we still have our bar book segment.
Yes, thank you for having me back.
You've mentioned some Latin maxims. Just give us one and its meaning. Since we have been talking about fair hearing, should I also still go back to audio pattern?
Audio pattern. The other side, and Nemo Judes in Cosa Sua. No man should be a judge in his own cause or in his own case.
Interesting maxims there, interesting, and we've seen it play out in every sector. And I have two that I would like to share with you. Alibi, we keep hearing about alibi. It's actually a Latin word, and it means at another place or elsewhere. It's a defense. And amicus curiae, it's a friend of the court.
Yes.
So you get to find out some other Latin maxims, interesting ones in our Bible segment. Well, that's much we can take this week on the Courthouse, and it was a very interesting session with Vincent Okoroafor, and he talked about the legal practitioners at the proposed amendments.
Thank you
so
very much.
So I must say a very big thank you to you.
Thank you to the viewers. Thank you very much.
I would like to see you some other time.
Thank you. My pleasure.
Well, we would like you to send your questions to us. Our question and answer episode is coming up in the first week of October. Send your questions and comments. You can use our hashtag the Courthouse, hashtag Love Applause, and you can download our app and also comment on the go. We'd like to visit our website on www.loveapplause.tv and send emails to us through info@loveapplause.org. That is all. Remember, don't just get mad, go get a lawyer. It's Olomu-Agbodo. God bless you. Okay, did not go.